So this is the second part of tonight's tutorial. And in the first part, we had Paul do his presentation on the Australian Armed Forces, particularly the aviation side of it, relying on his current role as being part of the aviation side of the Australian Armed Forces. And so he talked about the legal systems and how the legal systems in Australia internationally had an impact on the Australian Armed Forces. And we also had Manisha, who talked about the Infosys, which is one of the global companies. And she talked about the legal issues that confronted the organization, particularly in relation to corporate governance. So having listened to two fantastic presentations, and it's always very pleasing to see students come really prepared and able to do a presentation in a manner that's really very professional and very poised and confident. It's great to see these kinds of presentations tonight. We will now devote the rest of the time to talk about contracts and Australian consumer law for the purpose of kind of digging deeper into these concepts. Now, what we need to remember is that when we discuss or learn about contracts and Australian consumer law, these two topics are actually taught across one term. Actually, they're taught across two terms, especially when you look into remedies for breaches of contracts. But contracts, for example, in Australian consumer law as a distinct area of law in civil law, they're taught in one full term, and yet we're trying to know more about these topics in a week or 2 weeks at the most. So, and the bigger problem is we're doing it at the level of students who are actually involved in an MBA program, as opposed to a LAWS program. So there will be problems about the use of terminology about such as cause of action and so on, or jurisdiction and so on. But what we will try to do in order for us to learn more about contract law and Australian consumer law is to go through some problems, case-type problems. And in going through these case-type problems, we are then in a position to kind of elaborate on certain legal principles. Now, contracts and Australian contract law are obviously important from the viewpoint of business, because businesses enter into contracts all the time. So the contracts that businesses might enter into might be in relation to another business. It could be contracts in relation to suppliers, contracts in relation to major customers, and so on. It could be contracts in the sense that they put out an advertisement, and people respond to that advertisement. And the question then is, on the basis of the responses of individuals to advertisements, would that mean that there is a contract that then becomes binding on the organization? It could also mean instances when a company ends up hiring employees, and in that process there is an employment contract involved. And so therefore and it could also be that a company might, from the viewpoint of corporate governance, might end up coming up with a prospectus for the company. They may post something on their website in order to try to attract investors into the company. And what if in doing so, they make exaggerated claims? They make perhaps even misleading statements. Can the company be bound by those statements that they make? Especially if some of the claims can really be exaggerated. Say a company says, we're number one, we've got the sweetest ice cream or the best tasting pie, and that kind of statement, can it be that when somebody buys a product on the basis of such kind of claim, does it mean that there was a contract on the basis of the acceptance through the action of the consumer, so that if the claim turns out not to be what the consumer expected, that consumer can then say that there is a breach of contract? And so that's what we're going to do tonight. We're looking at contracts and contract law, and then look at Australian consumer law, which is a very distinct area of consumer law. Before we can understand, obviously, the idea about Australian consumer law, we need to learn about contracts, because Australian consumer law looks at contracts between a consumer and a particular organization. And as we will know later on, in relation to the kind of contracts that are covered, Australian consumer law will only cover those instances where the value of the contract between an individual and a business, for example, is only up to $40,000, does not exceed $40,000. So that will be the only time when it can be said that there is, in fact, a consumer contract. And so tonight, after studying this topic, you should be able to discuss and explain in general terms the nature and purpose of contract law, as well as the legal elements of contract formation, such as capacity, intention to create legal relations, offer and acceptance and consideration. And then you should also be able to discuss and explain in general terms Australian consumer law and the way it protects consumers entering into consumer contracts. So at the very start, it is important for us to remember what are the key elements of a contract. And we know that there will be a contract. And when I say it's a contract, something that's legally binding. And that is when there is legal capacity on the part of both parties. There must also be an intention to create a legal relation, because it's possible that there can be an offer and acceptance. That, in other words, there can be an agreement, but actually, notwithstanding the agreement, there was no intention to create legal relations. So, for example, there are some instances when in a family, for example, there is a family member who kind of supported his siblings or younger. And so therefore, when these siblings are usually dependent upon an older sibling have become of age and they are of good legal means, then they would say, oh, because you were so good to me when I was younger, I promise that until you turn 70, I will give you, as a way of paying back everything that you did for me, I'm going to give you, a gift of maybe $5,000 a year. And I promise that when you turn 70, I will even put you up in a retirement home. And of course, the elder brother says, fine, I'll accept that. That's a wonderful offer. So there is an agreement. There is a capacity for both parties because they are they have the proper legal capacity, being 18 years and above. But then we wonder, was there a contract? Was there an intention to create legal relations? And was there a consideration for the contract? Meaning, was there an exchange of promises or an exchange of prices for the contract? Because in the absence of a consideration, as we see later on, there would be no contract. And talking about consideration, for example, which is what we know in law to be the price which is paid for the promise in return for the other's promise. So that's the consideration. Does it mean that the consideration has to be substantial? So what if you end up, selling your TV, which would have been worth $1,000, and you say, I'm going to give you my TV for $1,000 on the condition you give me your book in exchange, even if the book is, say, worth $10 because I really like your book. Would there be a contract in the sense, in that case, given the huge disparity between, what one is exchanging for another? So these are some of the things we would like to get into in tonight's discussion. And I wonder how we proceed with the questions. Paul, I've got a question. Hang on. I'm not going to record it. I'm just going to stop recording for a while. So what we're going to do tonight, I actually prepared 10 questions, and we'll see how we go because it's 6:55 here, and it's, I think, 3:55 a.m. So Paul, is it 2:55 in the morning in the US? So we'll see how it goes. Okay, let's begin with question one. We'll probably take turns reading the question, Paul, because I don't want to strain your voice. But maybe for question one, you read the question, try to do the answer, and then I'll then add some add to the discussion. So can you read that question for us, Paul?
Okay, the Pond's Cosmetic Company claims to operate a scientific facility known as the Pond's Institute. They also sell cosmetics in the United Kingdom under the brand name Pond's Institute. Claims about the scientific side of the Pond's Institute include claims that the company hires hundreds of scientists from around the world to develop new and innovative skincare solutions for modern women. Many individual Pond's products make claims relating to their efficacy based on what are claimed to be the results of experiments or research at the Pond's Institute. In this context, if the company was to claim that an anti-wrinkle cream will make you look 10 years younger in 10 days, would you regard this as a binding pre-contractual representation or as a mere puff? Are there strong arguments to be made on both sides?
Okay, what do you think, Paul? I just remember I was talking to two traders just yesterday, and they were two electricians. He was an electrician. They were saying, "Oh, let me do the electrical job for you because I happen to be the best electrician in Brisbane." And then the other guy was saying, "Yeah, that's true. He's the number one, and the second best guy is actually just right across the road." And it's an exaggeration, right? You don't really believe that, but even if you do, and it turns out he's not really the best, would it mean that there was no binding agreement? You could just repudiate your agreement because he misled you. So that's kind of what we're doing now. Was that a mere puff that it could make the wrinkle cream is meant to make you look 10 years younger? Because if it is a mere puff, an exaggeration that that is not intended to be believed in, then in that particular case, it cannot be considered that there is the basis for a particular contract. What do you think, Paul?
Look, I'm not sure if I'm not exactly sure about this, but I would think that in terms of a binding pre-contractual representation, I think that the company's intent is to get you to buy their product, and if the reason you bought the product was because they said it made you look 10 years younger in 10 days, then I guess you could argue that it is a pre-contractual representation as opposed to a mere puff. If you actually went and bought the product, and I tend to agree that it's more puff. And how do you actually prove that that something makes you 10 years younger in 10 days? And there would be an argument that if you believe that, then potentially you're silly. However, that being said, if their intent was to, by saying that and to back it up with some fake scientific evidence or some anecdotal proof, I guess, then I guess you could argue that, yes, it is.
Very good. I actually agree with you on that, Paul. I mean, that's actually the second question. Are there strong arguments to be made on both sides? Because ordinarily, if one of the parties makes exaggerated claims, what we would call to be a mere puff, inflating, the efficacy of something and so on. In that case, these kinds of claims are really not intended to be believed in, and they're not really intended to. And a particular company can say that it didn't really intend to be bound by such claims, because how can anyone believe in what they're saying? So as a general rule, if a statement is really just mere puffery, it's an exaggerated claim which is not intended to be believed in and therefore not intended to be acted upon, then in that case, one of the parties who made that exaggerated claim can say that it never intended to be bound by those claims, and therefore it cannot be accepted, there can be no contract. But as correctly pointed out by Paul, in this particular case, this is Pond's company, a well-known company, which we can say really leads in terms of research and development into better skincare products. And so therefore, from the viewpoint of consumers, it is possible for them to argue that they really relied on the statement made by Pond's. And so following that kind of reliance on the assertion and the claim of Pond's, it can be said that the statement of Pond's was therefore a pre-contractual representation that, when accepted by consumers, ends up becoming part of the contract. So Paul is correct in that sense, because if you follow the case of Manufacturers Material Insurance Limited versus John Boardman Insurance Brokers Proprietary Limited, it is possible that in an instance when it is actually very possible for the other party to believe in an exaggerated claim, given the stature of the person making the claim, the expertise, and the experience that they have, the reliance by the other party on what may appear to be exaggerated claims can actually lead to a binding contract, because that would have been a pre-contractual representation. But if, on the other hand, the assertions and the claims were made by another person, and when you think about it, it's unlikely to be believed in. Like, you could probably go to the Brisbane CBD and you have a Greek restaurant there that says the best Greek food in the world. I mean, are you going to believe that, right? Or there could be a brewery there, a small brewery, and says this is the best tasting beer in the world, or even the best tasting beer in Australia. And it's kind of, it's not a well-known brand. So in those instances, it's just really, mere puffery, right? No one is, meant to believe that. And just because you therefore ended up buying their products doesn't mean that you've now made them bound by their claims, because in the first place they never intended to be bound by what they said. Okay, but in the context of what Paul was pointing out, that this is Pond's company, there is basis to argue that Pond's should be bound by its statements that the wrinkle cream could make a person look 10 years younger in 10 days, because that comes from Pond's. So that becomes a pre-contractual representation, and it's difficult to argue that it is a mere puffery or exaggeration coming from Pond's. Very good. Okay. Can you read question 2 again for us, Paul?
Graham's a slightly dodgy tyre merchant with a small workshop in an outer suburb. In his showroom, he has a series of tyres on display with prices and technical specifications next to them. Jill, who needed 2 new tyres on a car, came into the showroom, made a selection and went to the desk. When she asked Graham to replace the 2 tyres in the car, he responded by telling her he would do a special deal by giving her 4 of those tyres at a lower price per tyre. Jill said, "Look, for the moment, just replace the 2 tyres and I will check my finances and get back to you about the other 2. Graham responded, "Okay, but I will need to know before midday if you want the 4 tyres to be done." At about 10:30, Jill had still not responded regarding the 3rd and 4th tyres, and Graham had the opportunity to sell the last of his stock to another customer. He did so. He sent a text message to Jill to say he now only had 2 tyres to sell her, but she did not receive the text message due to delays in the mobile phone system. Before she received the message, she phoned Graham and left a message on his answering machine to say she wanted him to replace all 4 tyres. In relation to the scenario, is there a contract between Jill and Graham? Who is the offerer and who is the offeree? Why? And do any of the facts suggest an invitation to treat? If there's a contract, is it for the replacement of 2 tyres or 4? Was Graham's attempt to withdraw his offer successful? Why or why not?
Very good. Would you like to try to answer these questions?
Okay, so for the first one, I would say yes, there's a contract between Jill and Graham.
Okay, now remember there are 2 aspects to the transaction. One was in relation to the initial scenario where Jill was saying, "I only need 2 tyres," and then Graham said, you couldn't have 4. So where was the contract in relation to the 2 tyres, 4 tyres? Was there a contract at all?
So I would say there's a contract for the 2 tyres because she offered to buy them, he accepted, and I'm guessing there was a promise to pay money or a consideration.
Very good.
In terms of the 4 tyres, I'm not entirely sure. I would say that there's an offer there, but it wasn't accepted by Jill, although he did put a time limit on it of 12 o'clock. So, I'm not sure about the second question.
Very good. So I agree with Paul. In relation to the 2 tyres, there was a contract because, as Paul pointed out, Jill said she needed 2 tyres. Graham said, yes, fine, we're good with the 2. And then Graham said, how about 4? We've got a special deal. So in relation to the 4, however, was there a contract? Paul, let me just clarify that.
Yeah, no, I don't think there was in that case because she declined that second offer.
At that time. And
Correct.
when she got back, we will notice from the facts that so Graham said he needed for Jill to respond by 12 noon, by midday, in relation to the 4 tires, but Jill did not. And Jill only kind of responded later on. But even then, she only left Graham a message on his answering machine. What do you suppose are the effects of this one? That 1, Jill had not responded by midday, and 2, that Jill failed to actually talk to Graham and only left behind a message on the answering machine. What is the significance of that in terms of having a bargain or an agreement?
I think that there's the offer but not the acceptance part of the contract.
Very good. So for there to be a contract, what usually happens is there are mutual promises, there are mutual offers. So here there was an offer of Graham to give out to sell 4 tires to Jill, but Jill did not accept that offer. How about the fact that Jill said, "Oh, but I did accept it because I left a message on your answering machine"? Do you suppose that was enough to constitute the acceptance?
I'd say no.
Okay, very good. So the rule is,
because I think that I think the second offer, the four tires, while Graham did offer it, I think that she's coming back and confirming that offer, and so there's no mutual acceptance there.
Very good. So the rule is, if you want to accept an offer by the offeror, that offerer must know that you've accepted the offer. And until such time that the offerer has not known that you've accepted the offer, there can be no meeting of the minds. Okay, unless there was an agreement that you can just relate to me your acceptance of the offer by leaving behind a voicemail, but that isn't the case here. So there was a failure on the part of Jill to inform Graham that she had already accepted the offer, so there was no agreement. Now, this idea about an invitation to treat, what does it mean? Do any of the facts suggest an invitation to treat, particularly in relation to Graham's offer to giving 4 tires at a lower price per tire? So that was a special offer. Was that how do you call that? Was that an invitation to treat? Or by saying that, if said, yes, I'm happy to accept that, at that point, was there going to be a contract? So Graham said, if you buy 4 tires right now, I will sell you the tires at a lower price. And Jill said, great, I accept. If Jill had done that, was there a contract that then bound Graham to sell the 4 tires at a lower price? Or is there something that could be said merely to be a non-binding invitation to treat, or an invitation to kind of negotiate or to receive other offers? What is the nature of that particular offer on the part of Graham to sell the 4 tires at a lower price per tire? Was that capable of being accepted, which then bound both Graham and Jill? What do you think, Paul?
Yes. I would say that is an invitation to treat. However, she didn't take it up, so therefore, I guess it falls by the wayside.
Yeah. So the thing is, this is considered an invitation to treat. The crucial point about an invitation to treat is that it's really non-binding. So that even if somebody were to accept the invitation to treat, there can be no contract. The reason for that is that, let's assume for the moment that Jill does accept the offer. So Graham says, if instead of buying 2 tires, if you buy 4 tires now, I will sell that 4 tires to you at a lower price per tire. Even if Jill said, yes, I accept your offer, they cannot have any contract for the simple reason that they haven't really agreed on what the lower price per tire is. Is it $1 less? Is it $50 less per tire or so? So because of the fact that, it's really uncertain, the price is really uncertain, it only means that what Graham has done was actually to make an offer. It was just an invitation to negotiate further as to what those the prices of the 4 tires will be. So in relation to that question, therefore, the offer of Graham to sell to Jill the 4 tires at a lower price per tire was a non-binding invitation to treat, or it was simply an offer to negotiate, which meant that Jill would have been incapable of accepting that particular offer that would have led to a contract. Because for there to be a contract, there has to be certainty in terms of the key elements of the contract, particularly the price or the consideration that they were going to be paying. So the consideration on the part of Graham would be the tires. The consideration on the part of Jill would have been the payment. But because they did not know what the price to be paid was, the subject as to the consideration or the mutual bargains that they were paying to each other was absent. So there couldn't be a contract in relation to the 4 tires. Now, well, what had happened, I think, was that did he end up selling the 4 tires?
Yeah.
So what happened? He said he sold the 4 tires, not 2, but he sold the 4 tires. The question now is, was Graham's attempt to withdraw his offer successful? So did he have the right to repudiate the contract by saying, I had the right to sell the 4 tires because you did not get back to me on time? What do you think of that?
So I'd say yes.
Mm-hmm.
So I think that as you've explained just then in the invitation to treat, it's not a binding contract because they didn't agree on a price. So therefore, I guess you could argue that he didn't even have to withdraw a contract because there was no contract. I don't think he had any legal responsibility or legal requirement to withdraw that, but he did it out of, I guess, being nice to Jill so that she knew that he didn't have the tires anymore. That's
right. So because we earlier, Paul had already pointed out that there was a contract between Jill and Graham in relation to the two tires, but not in relation to the 4. So in relation to the 2 tires, when Graham sold those 2 tires as well, there was a breach of contract. Graham, however, there was no contract between Graham and Jill in relation to the 3rd and 4th tires. So in relation to the 3rd and 4th tires, Graham, had the right to withdraw his offer because it had not been accepted. And for as long as no acceptance had been communicated to the offeror was in a position to actually withdraw the offer at any time. So in relation to the 3rd and 4th tires, Graham had the right to withdraw his offer, and that would have been successful because Jill had failed to communicate to Paul her acceptance of the offer to sell the 4 tires. But in relation to the 2 tires, because there was already a contract or a binding agreement between Jill and Graham, then it could be said that Graham was in breach of the contract for selling the 2 tires. Okay, very good. Let's look at question 3. Do you mind reading question 3 still, Paul? You're okay? Up to it?
Yeah.
Very good. Thank you.
So Katrina and Richard were both big fans of the 1950s retro styling. Katrina owned a dress shop which specialized in rock and roll style dresses, most of which she designed and manufactured herself. Richard, on the other hand, ran a record store selling old-fashioned vinyl records. One day, Katrina came into Richard's store looking for hard-to-find music from the era. They fell to talking about their mutual hobby, and Katrina ended up placing an order to purchase the jukebox Richard had almost finished restoring. They stayed in touch for about a year as Richard set aside the rarest and most unusual records to give Katrina's of Katrina's first refusal. One day, Katrina suggested they should combine their efforts to start a business running a 50s diner, which would provide the perfect opportunity to showcase Katrina's fashion and Richard's music. Richard agreed enthusiastically. They were both experienced business operators and both understood the need to have their paperwork in order. They also recognized that running a partnership would be very different from each of them running their own businesses. They brought in a third partner, Emma, who had previously run a cafe before taking time off to start a family.
Continue, please.
Okay, so eventually they opened the business, and for a while it did very well, which resulted in even greater profits for Richard and Katrina's personal businesses. As they capitalized on the enthusiasm for the 50s, which came from the patrons of the diner. Along the way, Richard and Katrina found their mutual interests, and the time they were spending together led quite naturally to a personal attraction. By the first anniversary of the diner's opening, they were a couple. By the second anniversary, however, things were not going so well. The additional business favoured Katrina's personal business much more than Richard's, and both he and Emma felt that Katrina was not pulling her weight. The dissatisfaction was also putting pressure on Richard and Katrina's relationship. They all hung in there for as long as they could, but in the end, Richard and Emma have come to see you to obtain advice about whether they can terminate the contract they all signed when the diner was first opened. Advise Richard and Emma separately as to the following. What presumption will the law apply in relation to their intention to create legal relations under the contract? Who will bear the burden of rebutting that presumption? In the end, is the contract justiciable? Yeah. Yep. Okay, that word. And what is the strongest argument against your position?
Thank you, Paul. So what we're trying to look here is really the legal principle about entering into legal relations. This is important, for example, where the example I gave was, between two siblings, and the younger brother said, older brother, when you get older, when you turn 60, 65, 70, you're at the retirement age. If you ever fall into financial difficulty, I promise that I'm going to give you $10,000 a month. And in the meantime, because you've always been very nice to me, I promise to give you a gift of $5,000 a year. Now you will notice that there is a family relationship between the two. If a family member makes that kind of promise to another, is that intended to create legal relations? And if the one who made the promise then fails to fulfill that promise, can the offeree who accepts that promise sue the offerer for breach of contract? Let's assume as well where you've got husband and wife, and the husband says, he's probably in the military, he says, okay, I need to be deployed in Afghanistan for a while. I tell you this, while I'm away, if you continue to be faithful to me, no matter what happens, I'm gonna give you an allowance of maybe $5,000 a year, no matter what. Okay, so that's in the context of a couple. Does that mean that if it turns out that they part ways and the woman actually in fact lives faithfully and doesn't engage in some kind of other amorous relationship, can the wife then sue the ex-husband to fulfill his promise to give the ex-wife some money? So the question is, was the promise of the husband intended to create legal relations? So that's what we're discussing here. Because the general rule is, for there to be a contract, meaning a contract in law that is binding between the parties, there has to be an intention to create legal relations. And so when promises are made between family members, between friends, between lovers, people in very strong personal relationships, the idea is, they don't really intend to create legal relations. Fine, they may intend to make promises which they would like to fulfill, but courts don't want to be troubled by having to intervene when one of these family members does not fulfill part of his bargain. So as a general rule, therefore, when it comes to offers and acceptance of offers among family members or those with very strong close personal relations, even among very close friends, the general rule is that the parties do not intend to create legal relations in relation to their promises. They do not intend to be bound by what they promise. Even if it's accepted, there is no binding legal contract. Yes, there's an agreement, but you cannot sue the other party in court for breach of contract. Okay, so that's the legal principle. Now, in relation, therefore, to what had happened to Richard and Dema, let's go back to the facts. Okay, so it was Katrina and Richard who initially they didn't know each other. They went into business. After they had been in business, they had a romantic relationship. They brought in Emma, and after a while, the business didn't do well. They wanted to part ways. Now the question is, are they in a position to actually? So what happened here? So they would like to just terminate the contract with each other to be in this particular business relationship. So the question we have is, what do you suppose? What kind of presumption will the law apply in relation to the intention to create legal relations? Let's say between Richard and, what was the name of the girl? Katrina. And how about between Richard and Emma, or Katrina and Emma? What presumption will the law apply in relation to the intention to create legal relations under the contract?
So I think there was an intention between all three.
Okay, very good. Go on.
So the intention was you're talking about the legal contract to create this business, and I'm pretty sure I said in the first slide that they had all their paperwork in order. So I'm guessing
yes, very good.
They've got some sort of paper contract.
Yes, very good.
And it'll be interesting, I guess, in terms of cancelling the contract. There'll be some clause in there which talks about termination of contract and all that sort of thing. So without seeing that, I don't know whether or not they'd be able to cancel it. But in terms of their intention to create legal relationships under the contract, I would say that's it's well and truly proven and hard and fast if they've got paperwork to back up their starting that business.
Very good. So I am fully in agreement with what Paul said here. Given the kind of the paperwork they entered into and the contracts that they signed, it was clear that they had an intention to create legal relations. More so because the kind of agreement they were entering into was actually of a commercial nature. They were trying to get into business. So what this means is that even if in general we know that family members or those with close personal relationships, the kind of promises they make to each other are typically not intended to create legal relations and therefore cannot become a contract in law. But even family members or those with close personal relationships can in fact intend to create binding legal relations between them, especially in the context of commercial transactions, or especially when the contract happens to be in nature, as in this case. And more importantly, Richard and Emma, don't really have any romantic relationship. And even in relation to Richard and Katrina, when they first entered into this business relationship, they did not have any romantic relationship at the time. They were, private individuals who had no relationship to each other. So the fact that they may at some point have even gotten married does not change the fact that, the transaction they entered into initially was really not based on a personal relationship between them, but it was really one of a commercial nature. So what the law in this case will apply will be that there was in fact an intention to create legal relations under the contract. Now, let's assume, however, that one really says that, we were married, and let's say, you've got two persons, husband and wife, they decide to put up a bakery, for example, or put up a store. And so they work as partners, and they say, okay, no matter what happens, we agree that, one is going to be paying the other for the liabilities, and if you go into debt, I'll pay you, and so on. So these are husbands and wives. So the question is, in that particular circumstance, is it possible to argue that in that particular case, this is husband and wife, is it possible to argue that there was no intention to create legal relations under the contract? And if somebody tries to to say that there was no intention to create legal relations, who has the burden of, making that assertion?
I'm guessing here, but I would say that it's the person who is making the argument.
That's right. So anyone who was making the claim that he is not bound, or he or she is not bound under the contract, has the burden of rebutting, or proving that claim. And in the context of the husband and wife, because it's clearly a family situation, it's really arguable that they did not intend to create legal relations. So when somebody says, "I will pay for your debts," that was a promise that could be said arguably within the context of a husband and wife relationship, and therefore none of them really intended to create legal relations under the contract. So if one then says that, you are in fact bound under the contract, notwithstanding that we are husband and wife, that person will likely have to prove that the presumption does not exist. The presumption being that when parties are in a very close family or personal relationship, they do not intend to create binding legal relations with each other. So the one who tries to rebut that presumption has the burden of rebutting that presumption. Now, in relation to the contract between Richard and Emma and Richard and Katrina, is the contract justiciable? So when we say that the contract is justiciable, what it essentially means, the question it really raises is whether or not the court has jurisdiction and authority to deal with it. Because if it is an agreement between brothers and sisters or husbands and wives in the context of a family relationship, typically courts will say that the attempt to enforce a promise that has been accepted by the other among family members is one that is non-justiciable. It is one that is not apt for the courts to consider, because the court has no jurisdiction when it comes to these kinds of social relationships. So, do you suppose that the contract is justiciable?
Yes.
The answer is yes, because we know that the parties entered into a valid contract. It was clearly commercial in nature, and it couldn't have been affected by any romantic links, because they were not in a relationship at the time they entered into business together. Now, what is the strongest argument against your position? How can you argue, for example, that Katrina and Richard never intended to create legal relations under the contract? How can you argue that?
I don't know how you'd argue. I guess you could argue that maybe there was some sort of personal attraction before they decided to go into business together that wasn't evident, or maybe there was some intentions that weren't written down in the contract that perhaps Richard could argue, but I'm not sure how you would argue it in this case, given that if they do have paperwork to start up a business and everyone signed it.
That's right. So it's like, when a guy, for example, is courting a woman, the guy will make all sorts of promises. I will do this for you. I will do this and that. I will give this and that. I'll give you a ring. I'll give you a house. And then the guy isn't able to fulfill those promises. Can the woman now sue the guy that, you failed to fulfill your promises? And the answer is no, because there was no intention to create legal relations. And so while it would have been possible for maybe Katrina to say, or Richard to say that, we never intended to create legal relations, because we were kind of entering into a romantic relationship that is unlikely to be accepted by the court, for the simple reason that it was a commercial transaction that they had. Okay. So I'll read the questions here, and then maybe Paul can attempt to provide the answer. In which of the following cases would the law presume that there was no intention to create legal relations? 1, a contract between a barber and an old trusted client for a service unrelated to hair cutting. 2, a business contract between 2 old school friends who were the best of friends at school, but who have hardly seen one another for 10 years. 3, the purchasing manager of one business and the sales manager of another who are involved in an illicit love affair. And 4th, a mother whose computer is broken and her son who repairs computers. In which of those 4 cases would the law presume that there was no intention to create legal relations?
I would say I'd say the 4th one.
Yeah, that's right. This is the correct answer. Paul, have you taken up law?
What's that? Sorry.
Have you taken up law, or are you taking up law?
No.
You seem to be getting. You've gotten the 4 questions right so far.
Yeah.
That's good.
But I guess the with the 4th one though, it depends on the It would depend on the context of that as well. I mean, if the mother took her computer into her son's shop, and then there was dropped it off and said, how much to fix this, and he told her. He then went and fixed it. She came to pick it up and said, well, I'm not paying you because you're my son. I don't know. I think that kind of muddies the water a bit. I mean, I don't know what the court would say in that. But I mean, if the mother's at home and the son comes in and she says, "Oh, my computer's broken. Can you fix it?" He tries, fails, and then she tries to sue him for not fixing it. Then I guess that's a different answer, right?
That's right. I agree with you. So if the context were that the son had his own shop repairing computers, and certainly the mother drops it off, then there would have been an intention to create legal relations. But if the son is a computer geek living in the mother's house, or maybe even having his own house, and the mom just leaves behind the computer, in all likelihood they were relying on each other's the relationship they had with as mother and son, and there would have been no intention to create legal relations in that context. Very good.
Yeah.
Okay. Let's probably just move on to question 6. Which of the following statements is true? If an honor clause is breached, the innocent party may terminate a contract, but a court cannot award damages. An honor clause is not justiciable and therefore must not be written into a contract. The presence of an honor clause shows no intention to create legal relations. And an honor clause only takes effect provided the parties are honorable. So what is actually an honor clause? It's something that you insert in a contract or in when you're trying to make an offer, saying that, oh, this is in honor only. Okay, so it's like, let's just shake hands and, we do our very best. Okay, so so especially if you insert it into a written document and saying that this is an honor clause in honor only. So, I rely on your honor, that you're an honorable person and that you're going to do this. The question is that binding or not? So, which of the following statements is true? 1, 2, 3, 4.
So, I don't really know about this, but I would say that if an honor clause, if your intent is that it's not binding, then you probably shouldn't include it in a written contract. So I'm guessing number 2, but it's a guess.
Yeah, but you were referring to to the other point you were saying, Paul, was that if there is an honor clause, it means that you don't really have an intention to create legal relations. So when I say let's shake hands, you rely on my honor and I will rely on yours. We don't intend to create legal relations. Like I had a discussion with the builder. I'm getting a house built, and we had a dispute about the paint job. And so we wanted to change because we relied on the website about the paint, but there was a disclaimer that we needed to see the swatch. But they did not inform us that we needed to check the actual paint on a piece of paper. And so we were unhappy with the color. We had a discussion a few days ago. But the thing then was the builder was saying, if you want us to repaint the house, it means we're going to have to delay the completion of the house. and I didn't want that. So I said, okay, why don't we do this? In each other's honor, go on with the, with the completion of the house, and we will revisit this. And if we're unhappy really with the painting after, a week or so, we agree that I pay half and you pay half of the painting. But because we said this was, relying on each other's honor, there was no intention to create legal relations. So we just say, let's just shake hands and rely on each other's honor. That's an honor clause. And that means that you do not intend to create legal relations. Very good. Are you happy to proceed, Paul? Very good.
Yeah. So what you're saying then is you can write it into a contract.
Yes.
And as long as
In
you
a written
identify
document.
that
In a written document.
then as long as you identify that it's an honor clause, then it doesn't actually class as a contract. It
cannot become a contract. So even if you put it in a written document and it says it's an honor clause, then it doesn't become binding. So sometimes what would happen would be that there can be raffle tickets that are handed out by those small social organizations, and because the social organization doesn't really want to be bound by, doesn't want to be sued in the event there's a dispute, they may say that this raffle ticket, even if accepted, is binding in honor only. They might have that phrase. So which means that even when one person pays for the raffle ticket and gets the raffle ticket, assuming that there is a problem later on in relation to the raffle, the person who bought the ticket cannot sue on the basis of that raffle ticket, because in that raffle ticket was the phrase which said that this, any representations here or any agreements or statements we make are binding in honor only. So that becomes an honor clause. And because it is an honor clause, then it is not intended to create legal relations. So in other words, what we need to remember is that as far as contract law is concerned, the understanding is people should be free to freely enter into contracts, and they should also be free not to enter into agreements that are intended to be binding in nature. Because imagine if every single time you have an agreement, it has to create legal relations. There will be so much lawsuit, right? It could be like your neighbor. You say, okay, can we agree that we take turns mowing the lawn of this part of the common area? And then one of the parties does not do his part. Does it mean you'll end up suing each other? So the law recognizes that there will be instances when the parties don't really have an intention to create legal relations, especially when they just saying we're doing this on the basis of our respective honors. Okay. Let's go to question 7. Can you read this, Paul?
Alfred was in dire straits and badly needed some money. He decided to sell his 2016 Honda Civic on Gumtree for $12,000, but there was no taker. After listing his ad for 8 days without success and badly needing money, he listed it for sale at only $1,000. Jim swiftly pounced on the bargain and paid cash for the car. A month later, Alfred felt bad about the deal. The market value for his car was about $14,000. He's thinking of asking for the return of his car because there was no fair consideration for the sale. If you were to give him legal advice, what would you tell Alfred?
What do you think?
So I think he sold his car for $1,000.
Yeah.
I don't.
Was that a contract? Was that a valid contract? Was there a contract?
I think it was. Yep. He there was offer, there was consideration, and there was offer and acceptance and consideration.
How about the fact that the consideration was really low? What if Alfred paid only $100 instead of the market value of $14,000?
So I would argue that he needed the money, so to him it was, for a quick sale, it was worth selling it for $100.
Very good.
So yeah, I
like it.
So yeah. I think the value when say I guess he wasn't. He didn't seem to be under duress, even though he did need the legal money. Nobody was making him sell it for $100. So therefore, he came up with that number himself. So therefore, I think that it's a legal sale, and in terms of fair consideration, that was what he considered fair consideration at the time.
That's right. So there's such a thing as a peppercorn consideration, even if it's a peppercorn, for so long as it's a consideration, it's a price that is paid by one for the promise of the other, that is more than sufficient to seal the deal or to enter into a contract. So here, even if it's 100, even if it's meant to be 1,000,000, but you only paid 100, there is still consideration. It may be that the bargains are unequal, because somebody is certainly much better off than the other one, but that alone will not negate the fact that there is a contract, because there is a consideration. So here, Paul would be correct in advising Alfred that there was a valid contract, and therefore he can no longer ask for the return of his car and for him to just return the $100, $1,000 to the buyer. Very good. So even a peppercorn, can have a peppercorn consideration, that is still consideration. Okay, question 8.
You want to read it again?
I could read it and then you provide the answer, attempt to answer it. You could read it, Paul, if you could.
Okay. So Dale is a lovely fellow, known to be honest, generous, and utterly reliable. Heidi, his friend, has just purchased some new bedroom furniture, and Dale offers to save her on the delivery fee by collecting it for her. Heidi is concerned that Dale may forget to collect the furniture, so she decides to put him under as much obligation as possible. She has already agreed to babysit his children the following Friday night for just $20, which was a good start. While visiting him, she does his ironing without being asked, and conversation, she reminds him about the recent help she gave him organising a party. Has Heidi given any consideration for Dale's promise? If she really wanted it to be enforceable, what would you suggest you do? So this is the first question. I would say no.
Okay.
Because she was already going to do the babysitting, and he's paid her $20 for it. So
that's right. There was already a contract. Very good.
Exactly. As in the previous question, whether $20 is more or less is consequential.
Yeah.
And she did his ironing without being asked, so there was no offer and acceptance there.
That's right.
And the last thing that she reminds him about recent help she gave him. Well, there's no offer and acceptance there. That help was to do with this help that he's about to give her.
Okay. Now I'm not sure if I could ask I could add anything else, because Paul gave an HD answer there. Well done, Paul. Are you sure you're not taking up law? Or you're not a lawyer, Paul?
No, although I have had a lot to do with contracts.
Okay, fantastic. Now, if she really wanted it to be enforceable, what would you suggest you do, or she do?
Well, she needs to make an offer. So she needs to say something like, "Well, how about I pay you $10, or I babysit your children the following Friday night."
Okay.
And you do this for me, or something like that. There needs to be
fantastic. So in that case, there's a new offer, and there's a new promise, and when Dale then accepts that promise, you've got a contract. Fantastic. Well done. Okay. I still have 2 questions. You want to go on, but the questions 9 and 10 are pretty long. You want to go on, Paul?
Yeah, I'm good.
Okay, very good. I'll probably read question 9 just to take turns. So William, a 16-year-old university student, wanted to purchase a high-end gaming computer. So we're now looking into legal capacity. So we've talked about intention to create legal relations. We talked about agreements. We've talked about consideration. So we're now looking at the aspect of intention. We're now talking at legal capacity. And then in the final question, we'll try to talk about Australian consumer law. So for now, in this particular question, we're looking at legal capacity, remembering that in general, minors, or those who are below 18, do not have the legal capacity to enter into contracts as a general rule. Okay? So here in the question, William, a 16-year-old university student, wanted to purchase a high-end gaming computer so he could play his online games better and use it for his university studies. He checked out the computers sold by the Zenith Computers Proprietary Limited at its shop, the M-Wave Delta Force Recon Ultrathon Gaming PC, which has a $2,750 price tag, captured his fancy. William then asked Jeff, the computer shop's owner, if he could pay it in installments. He told Jeff that he would like to take the computer home upon payment of 50% of the purchase price in cash. He would then pay the balance in 6 months by installment and by bank direct debit from money that he earned while working part-time at a supermarket. William showed Jeff copies of his payslips to prove that he had the capacity to pay. Jeff agreed to William's offer. The parties then signed the shop's standard sale and purchase agreement that also contained their agreed payment terms. 4 months after the purchase, William's payment stopped. Jeff called William to ask about his delinquent payments. William explained that he had lost his job 2 months prior and could no longer continue to pay for the computer. Although this was the situation, William told Jeff that he was keeping the computer, considering that as a minor, he had certain rights that protect him under the law. So Jeff has now come to you as a solicitor for advice. Provide him a thorough legal advice as to his rights, if any. And for this purpose, for the purpose of this question, assume that the Australian consumer law does not apply. So we're just looking at the law of contracts, particularly in relation to legal capacity. So William is a minor, but he is a university student working part-time. He used to work part-time at a shop. What do you think?
So I think that because he's a minor, he shouldn't be entering into contracts by himself, and that I think the shop owner possibly should have got a parent and or guardian to co-sign the documentation with him.
Okay. Now let's assume that the contract has now been signed, and there was no guardian. William signed the contract on his own. Does it mean that he could get away with keeping the computer, even if he only paid half of the price? So imagine that somebody is there, he's a minor, he says, oh, I really need this because I need to stay in this, let's say in this hotel, or in this pension house, because I have nowhere to go. I know I'm a minor, but I really need to. You say, okay, you're sure you can pay? I said, yeah, okay then. So, you let the person stay, the minor stay. Does it mean then that when that minor is unable to pay the rent because he's a minor, you can no longer run after him in all circumstances because he is a minor? Or are there circumstances when a minor can in fact be bound by a contract?
So I don't know the legal answer to that question.
Okay.
I would assume that in the other example you gave, then you'd be within your legal rights to kick him out if he couldn't pay for the room. Although it may not be ethically right to do so. Legally, potentially you could do it. In this case, I don't think that the 16-year-old should be able to keep the computer.
Mm-hmm.
But legally, in terms of consumer law, I don't know how that sits. I guess you could probably chase him up criminally. You can argue that he's stolen the computer off you because he hasn't paid you the entire price.
Okay. Yeah, very good. So as a general rule, therefore, minors cannot be bound by contracts they enter into because they don't have the legal capacity the full legal capacity to enter into legal relations in the first place. So they don't have the legal capacity to enter into contracts in general. However, the common law, or based on decisions handed down by judges, there is a legal principle that when a contract with a minor is actually beneficial to the minor, and there are many kinds of contracts that can be considered beneficial. They can be for contracts over apprenticeship, like a minor works for another as an apprentice. It could be for education. It could be for employment. So even in these instances, even if the contracts are with a minor, but because these contracts are beneficial to a minor, the courts recognize that they can be valid and binding even if entered into by a minor. At the same time, there is another category known as necessaries, and necessaries can be clothing, they can be food, they can be shelter or homes where where a minor may live in. But when it comes to necessaries, therefore, the law also considers that a minor that enters into a contract in relation to necessaries would be bound by that contract. And the crucial point here is that it becomes a necessary if there are two tests that are met. One is that it is useful to the minor, and two, it is suitable to the state and condition in life of the minor. So it is useful to the minor, and it is what is suitable to the state and condition in the life of the minor. So it depends on the kind of minor. Not all minors will be the same. So somebody who is extremely poor as a minor, it can be argued that this computer is not a necessary because, why would somebody who doesn't have any money, who's a minor, coming from a low socioeconomic group, have a need for a computer? But in the case of this example, we have a 16-year-old minor who's studying in university. He does have a job. He used to have a job when he applied for a job, and he could argue that he needs the computer for his studies. It can then be argued that it is a necessary. And so because it is both, on the one hand, the contract is beneficial. On that ground alone, it can be said that it then is enforceable because it is a contract for a product that is beneficial to the minor. And at the same time, in this particular case, you've got a computer that can be considered to be a necessary to the minor in relation to his education as a university student. It is useful to him, and at the same time, it is suitable to the state and condition in his life. So in this particular case, there would have been, the contract would have been binding on William, and therefore if William fails to pay for the balance of the computer, Jeff can certainly run after William for the balance of the contract price, and William can just say, "Oh, I'm not going to pay for the computer." That's not possible for the simple reason that there is a valid and binding contract. Now we have a longer question consisting of 3 PowerPoint slides. This is in relation to Australian consumer law. Would you want to proceed with this, Paul? Very good. It's the last one. Thank you. Can you read it for us?
Okay, so on 4th of January 2016, Alex visited the Your Body Rocks Fitness Centre, the fitness centre, to look into signing up for membership. He was entertained by one of the fitness centre's fitness experts, Brad. Fitness centre has various fitness and leisure facilities, including a gym, tennis courts, badminton courts, sauna, swimming pool. According to the fitness centre's website, the centre is open to its members 24/7 and never closes. Alex, however, found the $120 monthly fee to be excessive and accordingly informed Brad that he was not signing up. Brad encouraged Alex to instead try their 1-month free trial membership and showed him the trial membership agreement. The agreement provides, among other things, that a trial membership will automatically change to a regular annual paying membership unless the trial member informs the fitness centre's management in writing no later than 15 days from the start of the trial membership that he or she was discontinuing the trial membership. The fitness centre may change its operating hours at its discretion.
Go on.
Oh, sorry, it just took a while to come through. The fitness centre may, without any incurring any liability, indefinitely. Oh, sorry, hang on. Sorry, that's my gym alarm. Suspend the operations of any of its facilities. The fitness centre may unilaterally vary any of the terms of the trial and/or regular membership agreement, and the agreement contains the entirety of the agreement of the parties. Alex expresses reservations about the above terms of the trial membership agreement. Brad assured Alex, however, that the terms were standard terms and the fitness centre always seeks to keep its members happy. Brad also assured Alex that he can cancel the trial membership just by sending him a text message, even at the end of the trial membership. With these assurances, Alex signed the trial membership agreement and signed a direct debit form authorising the fitness centre to automatically deduct any appropriate fees from his bank account. On 31st January, Alex bumped into Brad at the mall and informed him that he was not continuing with the fitness center's regular paid membership. However, Alex did not receive a reply from Brad. On 6th of February, Alex was surprised to find the amount of $120 deducted from his account from the fitness center. He called the fitness center to complain about this and told them that he'd already previously informed Brad that he was discontinuing his membership. In reply, the fitness center told Alex he was bound by the terms of the agreement he had signed and that any statements made by Brad were unauthorized. Hence, the fitness center would continue to make the monthly deductions. Alex has come to you as a solicitor for advice. Provide him a thorough legal advice to his rights, if any. Focus on Australian consumer law for this question.
Okay, now before we talk about the Australian consumer law aspect, let's talk about the law of contracts in general first, okay? So law of contracts in general, then we talk about Australian consumer law. So the first question we ask here is, was it possible for Alex to discontinue his membership with the fitness center and for him to seek a refund of $120, given the fact, according to him, that he had already informed Brad orally that he was not continuing his membership. Now, we know two facts, though, that one, based on their initial agreement, the trial membership could only be canceled if who's the guy here? If Alex informed the fitness center in writing not later than 50 days that he was discontinuing the trial membership. So 15 days from January 4 would have been the 19th of January. He told, therefore, he informed the fitness center only on the 31st of January. In other words, it happened, after the 15-day period. That's one. The second thing is that under the trial membership agreement, if Alex wanted to discontinue the membership, he was required to inform the center in writing, right? Where was that? Somewhere here.
Yeah.
Okay, but what Alex did was to just inform Brad orally that he was discontinuing the membership. So on those facts alone, without going to the aspect of Australian consumer law at the moment, do you suppose that Alex was within his rights to say that he was not bound by the contract and that he could just repudiate and discontinue his membership with the fitness center?
So I think this is a bit of a funny one because I think it would turn into a bit of a he said she said thing.
Okay.
However, Brad, I think that Brad, as a representative of this company, has inadvertently changed the contract. So on the previous page where he talks about don't worry about what's in the contract, all you need to do is send me a message or talk to me or something like that. Where's that?
Yeah, over here.
Yeah, assured Alex you can cancel the membership by sending a text message anytime during the trial. I think that there's an argument that potentially Brad has changed the written contract by representing that to Alex.
Very good. Okay.
And then Alex could argue that he only signed it because Brad made this representation.
Very good.
Obviously, Alex isn't a lawyer, because if he'd done it properly, he would have written that down on his signed membership form. But I still think that there's an argument that the contract has been changed by Brad.
Very good. So I would initially, my initial thinking really here was that, I wrote this particular question, but the initial view I had was that Alex was bound by the terms of the contract because he had, decided to discontinue the membership more than 15 days after what was in the written agreement. But you're correct. Alex could argue that there had been a change in the written contract. So, in the sense that Brad had made a representation that it was possible for Alex to discontinue the membership even after the end of the contract, even after the trial membership, simply by sending a text message. So there was a variation. Now, we don't want to move so much into contract law, but there's such a thing as known as the parallel evidence rule. So under the parallel evidence rule is that once the parties have entered into a written agreement, then no party is permitted to introduce any oral evidence to say that the terms of the contract have been changed. So you are bound by what is written in the contract. We're not discussing it right now. That's still, that's probably contract B. It's not even in contract A. So that's known as the parole evidence rule. The parties are bound by the terms of the written contract, because otherwise, if we did not adopt the parole evidence rule, then, as you said, it will turn into a he said, she said, and there will be no certainty in relation to the contract. But the common law also recognizes that even in terms of the parole evidence rule, there can be evidence based on oral statements that can be made to impact on the interpretation of the written contract if there was in fact an attempt to change the terms of the contract. So even if you have a written agreement, the parties can then say later on, oh, but we varied the terms of the contract orally, and that's allowed. Why shouldn't the parties be permitted to revise a contract later on? Of course it's allowed. It's part of the power of the parties to enter into agreements at any time that they like. So you are correct. You raised a very strong point there, Paul, when saying that there was likely a variation of the terms of the written contract when Brad, representing the fitness center, made a statement to Alex that he could do it even after the 15-day period. So that's a very good strong point. That's a very strong point. So it can go either way. On the one hand, Alex can argue, it could be argued that Alex could no longer be bound by the contract because relying on the representations of Brad, he did inform Brad, in about 26 days, and he did it orally, and that was according to the terms of the oral agreement that varied some of the terms of the written agreement. On the other hand, Brad can argue that, following the parole evidence rule, following the terms of the contract, you did not comply with the requirement for you to, to discontinue the membership, because the only time you can discontinue the membership would be 1, you did it within 15 days, and 2, it had to be in writing. So it's arguable. It depends on how you make the arguments. And either way, I think that would be a very satisfactory argument you would have made. Now, in relation now to the Australian consumer law, looking at this on the basis of an Australian consumer law, it can be argued that this is a consumer contract covered by the Australian consumer law, because you're dealing with a consumer that has a contract with a business, and the value of the contract is $40,000. So definitely, this is a contract that is covered by the Australian consumer law. The question now is, assuming that it could be argued that there would have been no way for Alex to repudiate the contract because he was bound by the terms of the written agreement. He had not informed Fitness Center that he would discontinue the contract within 15 days during the trial period. So let's assume that under the general law of contracts, Alex was bound by the terms of the agreement. The question now is, could Alex potentially repudiate or reject his obligations under the contract under the Australian consumer law?
So I'm not.
I could answer that if you like. Are you good at that?
I can have an attempt. I was going to say, okay. I'm not entirely sure of the specifics, but I thought there was some. There's a cooling off period for under the consumer law, in which case, if he fell under that, then he would be entitled to a refund of some sort. I think there's, from memory, isn't there like the company's allowed to charge an administration fee or
that's right,
costs incurred or something like that. But I don't know. I'm not sure what that is. Is it 30 days? In which case, if it was 30 days, then he's well within his rights to say no.
Very good. So that's one aspect which I wasn't really thinking about. But you're correct. There's such a thing as a cooling off period under the Australian consumer law. I was actually looking at the concept of unfair terms. Mm-hmm. Okay, so there is such a thing as under the Australian consumer law, where there is an unfair term in a contract, then that particular term would be void under Section 24 of the Australian consumer law. And we can say that there is an unfair term when that particular term, especially so we're talking in the context of a standard contract, what we sometimes call a contract of adhesion. So the contract between Alex and Fitness Center is a standard contract. it wasn't the one that they were free to negotiate, right? It was a contract of addition. You take it or you leave it. It's a standard contract. It wasn't within the power of Alex to ask for a change in any of the terms. So given the fact that it is a standard contract, it can be argued that when there is an unfair term here, because here the term in relation to the inability of Alex to discontinue, it could be said that there was an unfair term because there was a significant imbalance in the parties' rights and obligations under the contract. Like if you'll notice under the contract, the fitness center may change its operating hours at its discretion. So imagine that. The fitness center may suspend the operation of its facilities. The fitness center may unilaterally vary any of the terms. These are terms that are very disadvantageous to Alex or to the consumer. And so you will see that there is a significant imbalance in the rights and obligations, while on the one hand, Alex is bound by the contract for 1 year. It would appear that under the contract, the fitness center can just change the terms anytime. So that is one of the criteria. The second, it could be argued that these provisions in the contract are really not necessary to protect the legitimate interests of the fitness center. What is it there for? What is there to be protected? And the other question is, will these particular terms cause a detriment to the other party? It certainly will. Can you imagine thinking that you could use the gym anytime, and because it was meant to be 20, it never closes. That's what they said. And then it turns out that under the terms of the agreement, the fitness center can actually just change the operating hours anytime. So we can see that there is, that there are unfair terms in the contract. And for that reason, it can be said then that this particular contract can be declared void under Section 24 of the Australian Consumer Law. Okay, it's 8:08, and I think it might be 3 or 4 o'clock for Paul in Alabama. Is it 3 o'clock for you, Paul, or is it 4?
10 past 5.
Oh, 10 past 5. Okay, we've been together on this for 2 hours. So I think this is a good time for us to end the tutorial tonight. And thank you so much, Paul, for joining tonight's session. And I was beginning to think you're actually a lawyer because you gave great answers. If you were in the LAWS program, you would certainly have been getting high distinctions there. You got the answers correctly, and I like the way you think and argue. So well done. And so with that, with our gratitude to Paul for engaging in tonight's tutorial, I hope to see you again next time. Thank you, Paul, and enjoy the rest of your day.
No worries. Thanks, Manjo. Enjoy the weekend.
Thank you. Bye.
Okay. Bye-bye.